counsel, go ahead, whatever you want to for the record.
Yes, Your Honor. So after we were informed that they intended to call Detective Figueroa, as I was reviewing my notes last night, I noticed just a couple of potential issues. The first one being that Detective Figueroa's report is produced in two different exhibits. The first exhibit is produced in, and neither of these have been admitted into evidence.
Okay.
The first exhibit that his report is in is Exhibit 33, which is LVMPD's response to plaintiff's subpoena Ducis Tecum. And that set of records includes the traffic accident report, the lab reports, voluntary statements, property reports, as well as the collision investigation supplemental report, and the full EDR data. So EDR from the Hyundai and the Bosch EDR from the Dodge.
Okay.
The copy of it, and that copy is heavily redacted because that is LVMPD's policy to redact various items out of their reports before they produce them to the public. The copy that is contained within Exhibit 35, so what Exhibit 35 is sort of a mismatch of documents that we received from our client in relation to his criminal file. And so in this mismatch of documents was the criminal complaint, some of the traffic accident reports, the guilty plea agreements, it's just kind of, and then some of the testimony, things of that nature. This investigative report from Detective Figueroa is in that exhibit, but it is not fully complete within that exhibit, and it is unredacted.
How is that?
So it does not have the full set of the EDR data in that
was
exhibit.
produced somewhere else.
It was produced in 35.
And what are you talking about right now?
So the issue is the version within the hodgepodge of criminal document file from the client does not include the proper report that was produced via the subpoena. And it would be our position that we use Exhibit 33 for this witness, because that would be the proper document.
Are you moving to admit the report anyway?
No, Judge, nor are we moving to admit the actual EDR data unless we feel like we need to, but in either scenario, not the report.
Yeah, do we still have a problem then?
I do, well, now I have a different problem because I thought the whole reason we were calling Detective Figueroa in at least some respect was because the EDR data did not get in through Mr. Terry. So if they're not looking to introduce the EDR data, then why are we here? The second issue that I have though, Your Honor, is in the collision investigation supplement, and I don't know if counsel intends to do this or not, but I want to get ahead of this issue in case they do, is if you look at, and we're going to have to use 35 because it's the unredacted version of this. If you look at 35-0233 through 0239. The conclusion section of Detective Figueroa's report states it has his opinion that Collins forfeited his right-of-way by traveling more than 2.5 times the posted speed limit of 35 as he approached the intersection. Zaon Collins' actions on December 30th, 2020 were the collision cause that led to Eric Echevarria's death. The investigation is complete. It would be our position that that would be an inadmissible opinion from the detective pursuant to the Frias case amongst other Nevada authority that does not allow the officers to attest to the ultimate conclusions because it is for the finders of fact to decide. And it is not supported by anything else in his report, because then if you go on to the next pages, he does not cite to Nevada law, despite citing two different portions of Nevada law. He does not cite to Nevada law that would support that. So it's an inappropriate opinion. It doesn't have foundation, and it's a legal conclusion as to a law he does not even cite in his report.
Okay, before I get responses, I
Yeah,
thought that already came in because
Yeah.
somebody played a part of the video. I thought it was you guys that played the part of that video. Who
That's
played the
what-
part of the video?
We did, Judge, and,
Oh.
and that specific terminology was used about forfeiting the right of way due to traveling grossly in excess of the speed limit. In addition to that, Your Honor approved yesterday the language from the plaintiff's 16.1 disclosure, which specifically includes, amongst many other things, the issuance of traffic citations to defendant Marvin Collins, and
Although I'm a little, I mean, I don't know that there's a law out there that says this. Isn't there?
It's not
So-
contained in this report.
It says what, I'm sorry?
That says that you forfeit, like, okay, I'm gonna read exactly what's in the report. However, and it's the same thing he said on the video too. Well, I wouldn't say it's the same thing, but it's virtually the same thing. There might be a couple of word differences, but he did say it on the video too, and I'm sorry, I couldn't remember which one he played it. I thought it was played while Zaon was on the stand. I didn't remember who played it or why they played it, but I did remember hearing this statement in the video. And his report says Collins forfeited his right of way by traveling more than 2.5 times the posted speed limit of 35 miles as he approached the intersection. I'm not sure that's a correct statement of law.
It is, Your Honor.
And the video.
It is a correct statement of law?
It is.
What's the law that
That's the
says that?
law.
so.
It says, I can read it.
Yeah, show me what the law
It
is.
says,
Statute.
the driver of a vehicle within an intersection intending to turn to the left shall yield the right of way to any vehicle approaching from the opposite direction,
Yeah,
which is within the intersection
yeah,
or so close thereto as to constitute an immediate hazard.
yeah.
But such driver,
No, the rest of it's irrelevant.
having so yielded and having given a signal when and as required, may make left turn, and the drivers of all vehicles approaching the intersection from opposite direction shall yield the right of way to the vehicle making the left turn. So once they're not an immediate hazard, then the right of way switches, Your Honor.
Yeah, but that doesn't say what the officer said. That says your client has control of the intersection, and so therefore he has to yield to him, but not that going 2.5 times the speed limit or more than 2.5 times the speed limit is why he doesn't have rights. Like it doesn't say exactly that. I understand. Do you have something closer or no?
Well, Judge,
Is that it?
I
Just the
mean,
left
an
turn
important
statute?
portion of that is
Go ahead.
yielding the right of way to any vehicle approaching from the opposite direction, which is within the intersection or so close thereto as to constitute an immediate hazard. If it was just a blanket rule that you have to yield when you're making that left turn, no matter what, no matter how fast the car is coming or how far away they are at the time the turn is begun, then the legislature would have just cut it off after approaching from the opposite direction.
I'm not disagreeing with you at all what the left turn statute says. I agree with you. That's what the left turn statute says, that if you're turning and you have control of the intersection, oncoming traffic has to yield to you. But that's not what this says exactly. This says he's no longer within his rights because he was speeding, so he doesn't have the right of way anymore because he's speeding. And I'm not sure there's actual a statute that says that. But I understand what argument you're making. He's already in control of the intersection. He's safely making his turn by your argument. I know that's not your argument, but your argument is safely making his turn. Therefore, he has the right of way, right?
Correct, and he does not perceive the oncoming car as an immediate hazard, and the reason for that is because of the speed. And if defense wants to, examine the detective about that, then they certainly can do so.
He already said this in the video played. Was there an objection at the time?
So the video that was played did not say this. He said, you might have.
You guys have the video handy?
Yes.
We do.
You
Let's
know
play the
where it is.
video. Because he did say something like this in the video. I just don't remember the exact words he used, but it was very
He
similar.
says
to
you
this.
almost forfeit your right of way is what it's.
Right,
is
it
what
was
the
not
language
a,
is.
it was not a statement of the law that he did.
But, yeah, and
Okay.
And this is a statement of the law, right? Or purports to be a statement of the law that isn't quite a statement of the law. And allowing him to testify as to this particular conclusion, not only would bring undue influence to that opinion coming from both a detective and hearing it from the body cam, but if they already have it in on the body cam, why do they need him to testify to it?
Like way over 2 minutes. So there's a thing where, yeah, normally for you wouldn't be at fault for the collision. However, if due to the factor, you're going way above 2 minutes, you almost give up that right away that you had because you're going so fast.
And this is this guy talking, this is Figueroa.
That it is not, Judge. It is not.
Oh,
But I mean, this has already been played. And as I stated earlier,
is that Figueroa standing there?
No,
Oh, okay,
These are patrol officers.
okay. But I don't know, was there no detective ever called to the scene?
oh no, he was at the scene.
Okay,
We'll
Mr.
talk about that.
Detective Figueroa got to the scene.
Correct. And as is stated in the description of our testimony, it specifically encompasses the issuance of traffic citations to defendant Zaon Collins, which we discussed at length yesterday, and I thought we all agreed upon was within this the scope of what would be permissible today. And Your
Yeah.
Honor, Mr. Collins, he pled guilty to the reckless driving charge.
You know, you're
That's
gonna
it.
have this officer say that Collins forfeited his right of way by traveling more than 2.5 times the speed limit? Or are you just gonna have him say that, look, we did an assessment and based on everything I looked at, Collins was traveling 2.5 times as opposed to speed limit, and when we did our assessment, that was what we concluded caused the accident.
I mean, frankly, Judge, I didn't want to lead him too much. I was going to ask him what he concluded as a result of the entirety of his investigation. If you want me to be more.
Have you talked to him before?
I have not.
So you don't know what he's gonna say?
I have not a single time.
Your Honor, Marvin Collins' position is this is just like asking a traffic officer who's at fault for the accident.
This isn't like asking a traffic officer though, and this is very different than Prius because we've got like a full report where this guy's opinions were completely disclosed. So I understand why you're making that comparison, and I understand the issues. Trust me, I've cited Prius tons of times to exclude things. But at the same time, this is not a Prius situation where we've got somebody who actually did an analysis, an assessment, did an investigation of the scene. We know what he used, what he looked at, what he had.
And in that sense.
If I understand Frias, it's like an officer that came to the scene that, yeah. And this guy did come after the fact, but this is not like a brief assessment. This is where we've got, I mean, what's a traffic accident report usually? A couple of pages, and most of it is the information about where the accident happened. And we've got pages and pages and pages of this guy's report. It's
A 35-page report, Judge.
yeah, I mean,
And that kind of dovetail back into our position, Your Honor, is that the traffic accident Prius addressed, this is just a supplement to a traffic accident report. That being said, in this particular instance, this is clearly an expert that wasn't disclosed properly. And I know that was argued before, but
okay, as I asked your partner yesterday, what is the proper steps to take if an expert isn't properly disclosed?
we don't have to take any steps, Your Honor. It's incumbent upon the plaintiff to do their disclosures properly. And if they fail to do so, that is their burden.
well,
But that is our position.
my position is you have to disclose them. If they don't disclose them, then they're not going to be expert.
Hold on. The subject accident, their investigation thereof, all information, data, register, data, measurements complied, any photographs taken, the issuance of traffic citations to defendant Collins, all information contained in the resulting incident reports, as well as any and all relevant facts and circumstances. And you guys had this report, right?
Sure.
Okay, so
Disclose the report.
here's what happens if there's a disclosure issue. You do a motion. And you do a motion to compel it, and then they give you whatever you're missing. What were you missing here that you would have gotten that would have helped you assess whether or not these can come in? That you'd never asked for? Like, this is a discovery motion, and I understand if you've never seen this report before, we'd be in a different situation. If they didn't actually put this in disclosure, again, we'd be in a different situation. But if you have a discovery issue, you make a discovery motion, and then it's not, we don't go right to strike, do we? I mean, I've never gone right to strike in discovery motions. You do a motion to compel, they produce whatever information you think is missing. What were you missing for the expert report? What else should have been produced with this? Was
They should have,
properly produced expert. What should they have given you?
they should have given the proper disclosures pursuant to NRC 60.
Tell me what that is.
I have it here in front of me, Your Honor, but they should have laid out.
Okay, I can tell you
all-
what it is. It's a resume, a fee schedule. Go ahead.
All of his opinions, including this opinion that they want to get in backdoor because their expert was absolutely atrocious. So their expert came in and testified that Mr. Echevarria had to yield the right of way. He still had the duty to yield the right of way. Now they're bringing in a detective to impeach their own expert. That's not appropriate.
Okay.
Additionally, I apologize, Your Honor.
No, go ahead. Go ahead.
And under 16.1 and under these new disclosure rules that we're all laboring under, even if it's a non-disclosed expert, you have to do a disclosure that is consistent with what, even if they were disclosed specifically, what specific, in this report, what specifically was he going to come in and testify to? There's one little throwaway line in there, misstating the law. And that's what we want to exclude. Thank you.
Response, go ahead.
First of all, respectfully, council's just saying words. Yesterday, we were accused of having this expert, Detective Figueroa being duplicative of our expert, and now the accusation is we're using Detective Figueroa to impeach our own expert. Detective Figueroa is not someone we brought in as an independent consultant. He was the assigned lead detective for Metro Fatal Detail, who personally led the investigation into this crash. He's going to testify based on fact, based on personal observation, and he will discuss his findings and his conclusions. And to the extent that they have any issue with anything that's stated in his testimony, which will likely come from his report, which we're not seeking to admit, they can cross-examine him on it. And as Your Honor was hinting at yesterday, they were aware of Detective Figueroa, both his opinions, because the report has been disclosed for a long time by both parties. He was listed in our pretrial disclosure. They've known we're going to have him testify. Where's our motion in limine? Hey, motion in limine to preclude Dr. Detective Figueroa from offering opinions as to ultimate issue or whatever may be the case. We're dealing with this now when he's waiting out in the hallway. On the merits, we think we still win, but this is procedurally,
Okay.
pretty wild.
Go ahead.
So, first of all, they had a disclosed expert, Sam Terry, that talked about all of these things. So to think that they would have put up a detective to talk about the same opinions that Sam Terry was disclosed properly to do could not be anticipated. So yes, we are dealing with this in the middle of trial, because not once during any of our pretrial discussions have we heard, okay, we're going to also call Detective Figueroa to testify to his findings, because we had an expert that was lined up for that purpose. But I think outside of, and I maintain all of my objections that we've enunciated this far, that it's cumulative, it's duplicative, all of those things. But I understand the court's ruling. So my direct remedy that I'm asking for right now is just that line I pointed out on 35-0233 is a misstatement of the law, and he should not be permitted to testify to that sentence.
Okay.
Or anything related
So
there.
here's where I am with this. Here's where I am. And then you guys will have a very short time if you want to make additional comments after I tell you where I am with it. And then we're going to bring them in and we're just going to start the testimony, because this kind of stuff, that now is not the time to be bringing these motions or these issues. Okay. Yesterday, the objection I was hearing from the defense side was that this guy was an improperly disclosed expert. Okay. I ruled on that objection yesterday. I ruled on that objection that that motion should have been brought as a discovery motion during the discovery phase of this, that there are remedies for that, and that the initial remedy and the initial request when you bring such a motion is not to immediately strike. You get the information you need. You tell me how you're prejudiced by this. And honestly, you guys were on notice. The disclosure says LVMPD officers, forensic scientists, detectives, crime scene analysts, and sergeant identified above, which Detective Figueroa, is identified above, was the investigating officer at the subject incident. It's anticipated that they will testify regarding the subject accident, their investigation thereof, all information, data, measurements compiled, any photographs taken, the issuance of traffic citations to the defendant, Zaon Collins, all information contained in their resulting incident reports, as well as any and all other relevant facts and circumstances. So the argument that this is a undisclosed expert and that you didn't know what was gonna happen, it's gone, okay? It was disclosed. The report was disclosed. This should have been brought as a discovery motion. As I said to your partner yesterday, Mr. Johnson, I hope he talked to you about it. This was an improper way to bring such a motion and the improper time, and to ask for the sanction that's being requested is not appropriate either, okay? There should have been a discussion with opposing counsel. We want X, Y, and Z to have this person, and we want you to exclude him. Then you do the motion. It goes in front of the Discovery Commission. They make a ruling. And it goes through a whole process that didn't happen here. So we're not going to skip that process now, because procedurally, I do believe it is flawed to do that. Okay, so now we get to the objection today that I'm hearing. The objection I'm hearing today is that there's an improper statement of the law in his report that you are seeking to exclude him from saying. Is that correct?
That is correct, Your Honor.
Okay, so the objection that this is an improper statement of the law, I am not seeing anything in the law that says this is a proper statement of the law. However, he needs to be limited. He's not to give statements of the law and what the law is. Is he in his uniform?
I believe,
No,
I don't.
no, he's in, I think
He's in
a suit.
plain clothes.
Yes, he's in. a suit.
Okay, and I'm only asking that because if we bring a uniformed officer into this room and then he gives testimony, it's gonna sound like he's giving testimony on what actually the law is. If he gives testimony to this effect, you are not to elicit it as a statement of the law, okay? So just be careful with your questions that it's not trying to elicit a statement of the law, okay? But if you are asking for his opinion, for his assessments, for things that fall under this category, and I understand that we've got a freeze issue here too, but here's the thing. Notice, and it's not the same thing as Frias when we've got a, what, 35-page report here? Let me see if I'm correct. I think it's actually more than 35 pages. Oh, no, actually, it's almost exactly 35 pages, 34 pages, I think. It ends on page 239 and starts on page 205. So we've got a 34-page report that clearly went through what he did, what he looked at, what he assessed. You had all this information. The only information you arguably didn't have was what would have normally been disclosed in expert disclosure, probably whatever else he's testified before, anything he's published, and so forth. But you could have asked for that in discovery, and you didn't ask for that in discovery, and then you could have compelled it when you did get it. Okay, so that being said, he's not to make statements of the law. If he makes a statement that sounds like it's the law, you can ask for an instruction that this expert or this witness is giving his opinion based on his assessments, based on the examination he did at the scene. It's not intended for this to be a statement of the law, okay? You are welcome to ask me to give that instruction. You are welcome to object. And like I said, with your questions, be careful that you are not trying to elicit a statement of the law. If he gives one, because you're telling me you don't know what he's going to say, then we'll deal with it when it comes out. But that's the only way I think we can deal with it at this stage, because this objection was not brought up yesterday. If this objection was brought up yesterday, what we would have talked about is bringing him in early. I would have had the jury come back half an hour later. We would have had a discussion with him. But at this point, when I've got jurors waiting outside in the hallway, they're all ready to go. He's ready to go. I'm not inclined to now spend half an hour coaching, or I don't want to say coaching, but it's essentially instructing the expert what he can and cannot say.
Judge, if I preface the questions with, detective, without citing any specific statutes, what were the conclusions that you drew in this case? Something like that. Is that acceptable? I just want to know if, for instance, he still talks about right of way or forfeiting right of way. Is that going to be construed by Your Honor as a statement of the law, even if he's not citing any actual statutes? I want to make sure we stay within bounds here.
Wait, repeat what you just said, please.
If I was to preface a question to the effect of, detective, without citing to any specific statutes,
Yeah,
what conclusions did you draw in this case as a result of your total investigation?
preface a question without citing to specific statutes. What conclusions did you draw? Yes, and then if he gives a conclusion that sounds like he's giving the law, you object, and I'll give the instruction that this witness is giving an opinion, and that the intention herein is not that he's giving a statement of the law. Okay? That's the best we can do at this stage.
Thank you, Your Honor.
Okay.
And if that doesn't make sense, then ask me what you want me to say. Give it to me, write it down, and if it looks like it makes more sense or is more clear, I'll do it that way.
Okay.
You have a media release, right? Yeah. Okay, you got a media release? Just want to make sure that it's signed and done. Okay, because I know they did. As long as you got one, it's fine. I just don't want to. It's filed in, is it in my? Okay. Okay, anything else before we go to the next thing?
No, Your Honor.
No, Your Honor.
Okay, are we ready to bring them in?
Yes, Your Honor.
Yes, Your Honor.
Sorry to single you out, sir. I can look for it right now if you're worried. But you said it's there and I've got it, right? Okay, great. Okay, thanks. Ladies and gentlemen, welcome back. Thank you very much for coming again today. Counsel, do you acknowledge the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Okay, plaintiff's counsel, are you prepared to call your next witness?
We are, Judge.
Okay, go ahead.
Plaintiff's called Detective David Figueroa.
Stay standing, raise your right hand, and my clerk's gonna swear you in.
You do solemnly swear the testimony.
Do.
Please state and spell your first and last name for the record.
First name David, D-A-V-I-D, last name Figueroa, F-I-G-U-E-R-O-A.
Thank you. You may be seated. Be sure to bring that mic real close to you and that the little red button is up.
Good afternoon, Detective.
Good afternoon.
Detective, where are you currently employed?
With the Las Vegas Metropolitan Police Department, fatal detail,
And how long have you been employed by Metro?
approximately 19 years.
And I'm referring to you as a detective. You are a detective, is that right?
Yes, sir.
And you said you're with the Fatal Detail Unit?
That's correct.
Can you tell us about the training you've received during your time with Metro, specifically pertaining to motor vehicle collision investigations and reconstructions?
I transferred to the Traffic Bureau approximately 16 years ago as a motorcycle uniformed officer. Basic accident investigation training, DUI training during that time. Approximately 9 years ago, I was promoted to detective to the fatal detail. And that training required extensive training, several different universities. I attended to take classes as prerequisites for a detail for a detective position in that unit, and that entailed University of North Florida, Northwestern University. I did training with the Ohio State Police, a bunch of other classes, advanced classes in traffic reconstruction,
Okay.
accident reconstruction, sorry.
No, you're good. And these courses you're referring to, this additional training, this is specific to the field of motor vehicle collision investigation and accident reconstruction?
Yes, sir.
Are you trained specifically in the field of crash data analysis?
Yes, sir.
And just generally speaking, what is black box data in your world?
We don't refer to it as the black box. That's an airplane.
Okay.
It's a airbag control module, and what that is it's a module that is designed to store data related to a crash.
I was actually going to ask you next, is that also referred to as ACM, but that's what you refer to it as, ACM or airbag control modules?
Well, primarily, yes. They also have event data recorders. Certain manufacturers and certain modules are referred to differently by the manufacturer who makes those devices.
And that varies based upon type of vehicle, I assume?
Yes, sir.
Okay. And you said you've been a detective with Fatal Detail now for about 9 years?
Correct.
And this probably sounds a bit obvious, but what is the Fatal Detail Unit's role or function within Metro?
So we respond after the fact. So when a collision occurs and it meets the criteria of life-threatening injuries or fatalities, the responding motorcycle uniformed officers along with patrol, once they find out that information, then they initiate a call out, and we get contacted primarily from home. It's usually when we're off duty, and we respond to assume the primary investigative responsibilities.
Do the traffic officers, motorcycle officers who arrive first on scene, do they conduct a preliminary investigation typically before turning it over to fatal detail?
Yes, they do.
And then with fatal detail arrives on scene, will you typically be briefed on that preliminary investigation by the traffic officers?
That's correct.
And when the fatal detail unit is summoned to a scene, is there typically one detective within fatal detail who is assigned as lead investigator, or do you all work collaboratively?
Well, we work on a rotational basis because of the caseload. So whatever a detective is up at any given moment, a call out is initiated, then the team will respond. But as you kind of explained in your question, the primary investigative responsibility is falls on that detective who is up next to assume those responsibilities.
When you are tasked as the lead investigator of a fatal motor vehicle collision, what are your primary duties and objectives?
As the lead,
Yes.
there's some flexibility, but primarily you conduct the interviews. You are responsible for the collision supplement, which is a report that's supplemented from the preliminary investigation conducted by the motor officer. You, with the help of your team, you gather the case together and submit for prosecution if that case that you're investigating deems that criminal charges are going to be applied.
And detective, did you serve as the lead detective for a motor vehicle collision that occurred at the intersection of Fort Apache and Furnace Gulch Ave on December 30th of 2020?
Yes,
And did you prepare a collision investigation report in regard to that particular incident?
I did.
And do you have a copy of that with you by chance?
Don't.
All right, and so I'm going to ask you some questions about that particular investigation, and the crash occurred several years ago. If at any point you feel like it would be helpful for you to refer to or refresh your recollection by looking at your report, let me know, and we can give you a copy of your report, okay?
Sure.
All right, so let's test your memory right away. Do you recall what time of day this collision occurred?
It was nighttime. I don't recall the actual time now.
All right, would it help if I refresh your recollection
Sure.
with a copy of your report? Your Honor, may I approach the witness?
Yeah, as long as he's okay with it.
Yes.
It's okay.
Yeah, go ahead.
Yeah, I don't object the detective having his report.
Your Honor, there's a stipulation on file January 31st of 2025 that says that law enforcement testifying may, while the reports themselves are not admissible, may refer to their reports while testifying.
I don't have an objection to that.
I think he thinks you are objecting.
Oh,
That's, I was wondering why you were saying. that.
Why did you stand up like that?
Doesn't want to be cool about it. You can have this report. So
I made a good point though, huh? All right, Brad, will you help me out, please? And hand that
got
to
it,
the
my
detective.
friend.
All right, thank you. I got indignant there. I'm sorry. All right. And detective, does the report that was just handed to you appear consistent with the report you generated as a result of the collision I mentioned?
It does.
And is the time of day of the collision referenced anywhere?
It's right. It should be referenced. It's on the cover page and then the within the synopsis of the report.
Okay, and what time of day did the collision occur according to your report?
3:23 p.m.
Okay, now you said nighttime. Did you personally go to the scene of this crash on the day it occurred?
So on average, a 911 is contacted, patrol responds along with traffic officers. Once they figure out what they have and it meets the criteria, as I explained earlier, with life-threatening injuries or a fatality, we are then notified. As I said earlier, we're primarily responding from home, the respective detectives from their respective homes. We have to get dressed, get out there. And so usually it's 2 hours, 2.5 hours-ish, depending on the proximity and location of the crash. So when we arrive, I remember arriving on this particular day, it was, if it wasn't close to being nighttime, by the time I arrived, it was already nighttime.
Okay, and it sounds like there's nothing unusual about arriving a couple
No.
hours afterwards?
No.
All right. And were you joined at the crash scene that day by other members of the fatal detail unit?
I was.
Is that typical?
It is typical. We respond, case like this, and what I mean is a fatality confirmed. We respond with 3 to 4 detectives along with a sergeant. And then upwards. Our unit has expanded now, so we now have 2 teams of 5 detectives. It used to be 2 teams of 4 detectives. And so, I'm not sure if we were a 4-man team, probably 5 years ago, yes. So 4 detectives max and a sergeant.
So with all of the officers who work for Metro and work in traffic, there's only 10 currently, and at least back some time, only 8 total who are tasked under the fatal detail unit.
Yes, it's very, we're very short. And the 2 teams work in rotation, so each team is up for 2 weeks, off for 2 weeks, and then the additional team segments.
Now, the 3 other detectives approximately who would have gone to the scene with you, they're from the fatal detail unit, is that right?
Yes, sir.
All right. And when you arrived on scene, were you briefed by the responding traffic officers about the collision's preliminary details we discussed earlier?
Yes.
And from the point where you arrived on scene and you received that preliminary briefing, can you take us through the pertinent aspects of your investigation from that point forward, at least for the remainder of that day?
That's almost 5 years ago. I can give you the usual, and then I guess you can ask for specifics. But I would make contact with the motor officer uniformed who is assigned to the call. When they feel comfortable enough that they have the information that they need for the basic briefing to detectives, we then huddle around our truck usually, and they provide the preliminary information as they know it to be. Notes are taken. And once that briefing, it's extensive, 15, 20 minutes in terms of just basic stuff. Then certain tasks are carried out by the respective detectives. The primary would then, primary investigator would conduct his interviews while the other team members do their respective jobs, and that's usually delegated by the primary investigator. So I would say, hey, can you do this, and can you do this, and can you take care of that, and so on. If that makes sense.
It does. It does. Your report indicates that yourself and the other fatal detail detectives began by walking the collision scene to familiarize yourselves with the evidence in collision dynamics. What does that mean?
So, as I said, the preliminary investigator, traffic officer, he gives us the dynamics of the crash as he knows them to be, or she knows them to be. We then walk along the roadway. We start off, it depends, but usually we start off in the direction that the crash was happening to identify roadway evidence. We come back the opposite direction, north, east, south, and we're trying to identify roadway evidence. In this case, there was a debris field. And so we're identifying vehicle parts. And then when these vehicles came to a final rest, we are looking at the vehicles as well.
And does your investigation include taking photographs?
Well, not by myself, but we have a crime scene analyst that responds and does that.
Okay, so a crime scene analyst responds in conjunction with the other officers for purposes of, among other things, I assume, taking photographs of the scene?
That is correct.
And as part of your investigation of motor vehicle collisions in general, do you typically try to identify the AIC or area of initial contact?
Yes,
Why is that important?
because that gives you the location of where the crash occurred, meaning in this case, two vehicles collided, the area that they collided in is
And-
important.
And what are you typically looking for in order to make that determination?
Roadway evidence is usually the tell, if you will, as they say in poker. Redirections, you can see scuff marks, meaning and you can see gouge marks. It's in some cases you cannot, but usually roadway evidence is the tell.
Okay.
And then if we have the availability of video evidence, then we can also look at that as well.
Okay. Joe, can you pull up Exhibit 7-121? These are pre-admitted photographs. And Detective, I know, like you said, this accident was 4+ years ago. Does this appear to be consistent with your recollection of the scene, at least from one angle?
Yes.
And can you tell us what we're looking at in this photograph with respect to the items that are placed in the roadway and the areas that appear to be painted?
So in this case, these small orange cones is what you see. That's the bottom of the cone facing us. That's why they don't look as you would normally see a cone. We place those cones down in this particular case to highlight the second vehicle or the first vehicle, whichever, I don't recall. So one vehicle, so we can see the distinction, we'll lay cones up. The other vehicle, we'll lay the cones down. If there was a third vehicle involved, we'll turn those cones to the side, just to articulate which vehicles roadway evidence we're identifying.
Understood. And you can see it's fairly dark out, and we have street lights there. Is this consistent more or less with the lighting of the area when you arrived on scene?
I don't recall. I mean, it was, yeah, when you mean, if you mean dark, nighttime, yes. But as far as the illumination, I can't be at.
Do you have any reason to believe that your investigation was limited or adversely affected at all based on the lighting conditions upon your arrival?
No.
Okay. And Joe, if you could go forward one more photo to 121. And go forward one more, please, to 122. All right. And Detective, it appears as if there's some additional cones there kind of to the right of that line we saw before, as well as some writing or some letters there in the roadway. Do you see what I'm referring to?
I do.
Can you tell us what we're looking at?
AIC is painted in white. Is that what you're referring to? Yes. Area of initial contact.
Okay, so that's the area of initial contact between the two vehicles.
Yes.
Based on your investigation?
That's correct.
And then the cones that are there to the right are, what are those intending to?
So as I was explaining on a previous question, you see cones that are upright, and those cones belong to the decedent's vehicle.
All
So
right.
that's the roadway evidence that was deposited on the asphalt, and it's highlighted by a different color paint. And the cones in the upright position.
Joe, go forward one more, please. I'm not sure if we need it, but okay, I think we're good. Yeah, you can go ahead and pull it down. I asked you a couple of general questions earlier about what I,
The exhibit needs to be pulled down.
oh,
Please.
yeah, Joe, you can pull it down. What I referred to as black box data erroneously. With respect to ACM data, in your world of motor vehicle collision investigation, is this the type of data that you typically or commonly rely upon in the course of your investigations?
I wouldn't say relied upon. It's a piece of evidence. And so um with the amount of data that is being required by these manufacturers, by the federal government statutes to have stored on this device for crash investigation purposes or crash data, um, that increases as the years go by. But we do not just rely on one piece of evidence. It helps us understand the crash dynamics, but there's other methods we use to confirm or deny the data, if that makes sense.
It does. So the ACM data is just one data point, if you will, amongst any others that you can derive through your investigation?
Correct.
And in this instance, were you able to obtain and review the ACM data for the vehicles involved?
Yes.
And I don't know if I asked this before, is part of your training, has that included the review and analysis of ACM data?
Yes.
Can you walk us through the actual process undertaken to obtain the ACM data from the Dodge Challenger that was involved in this collision?
I don't believe I imaged the data. So there's two steps. First step is, in this case, I believe I have to read through it, but I believe a warrant was obtained to image that data. That was done by a detective other than myself. And that was for both vehicles. And then reading the data and interpreting the data was done by me as the case agent.
Understood. And that was for both vehicles?
I believe so. If you
Okay.
give me a minute, I can confirm, but yes, a detective other than myself imaged both vehicles. So in other words, we don't download the data. The data is in a module. We image it. So it's still in that data to make available for discovery for whoever needs to see it.
Including yourself?
Correct.
Okay. And
So-
upon your review of the ACM data for the Challenger, can you take us through any of the findings that you made that you deemed pertinent to your investigation?
So that data, we use a special software, and that software interprets the data into a readable report. And in this particular case, I believe it gave us, are you referring to which vehicle?
To the Challenger, I believe on page 28 of your report, which is
So
Bates number 232.
I believe on that module, it gave us 5 seconds of pre-crash data. So 5 seconds prior to a command that was initiated for the vehicle to deploy airbags.
And what findings from within that 5 seconds of data did you identify that you deemed pertinent to your investigation?
We have, would you like for me to read it, or because I don't remember off the top of my head?
Not necessarily, if you want to take a moment and just
Okay.
scan through
So,
it.
so we have a top speed within that 5 second period, which was, I believe, 2.5 seconds. It says that the vehicle's traveling 88 miles an hour. 5 seconds prior, the vehicle was at 85 miles an hour, so it sped up a little bit. It also gives us information that when the brakes were applied, if seatbelts were worn at the time of the crash, and steering input in this case.
So the black box data revealed that the Challenger was traveling 88 miles an hour at 2 seconds pre-crash. Is that correct?
Approximately 2 seconds, yes, sir.
Okay, and when were brakes applied?
At 1.7 seconds prior to airbag deployment command.
And were you able to determine or estimate the speed of the Dodge Challenger at the moment of impact?
So the module detects the way it's designed. It detects a velocity and change. Hey, this is something that I have to record. And the vehicle gives a command that says, hey, I need to deploy airbags. That's what that module is really about. So when you say crash speed at the time of impact, this is milliseconds prior to. It's
Right.
algorithm or enablement. And what that means that if in the report, as you see, that a command is saying we're about to crash, deploy airbags.
And what was the speed according to the ACM data in those milliseconds prior?
It's about 61 miles an hour.
And you mentioned that this particular module gives us steering input data as well.
It does.
And what was revealed in that respect within the Challenger's ACM data?
So it tells you a degree of turning movement on the steering wheel. And in this case, the steering wheel was turned to the right. And as the ABS was engaged,
ABS being the brakes.
the brakes.
So I believe you said that was right around 1.7 seconds prior to the impact.
Correct,
And the steering wheel was engaged to the right, as you said.
correct.
All right. And is there a severity of angle that is in terms of the data that's offered from the steering wheel input,
Severity,
or extent? I didn't mean.
yes.
Maybe that was a bad term to
It
use.
tells you basically what the operator of that vehicle was doing in
Okay.
terms of how many degrees that vehicle was turned, whether it's left, right, or if it was not turned at all.
And how many degrees are we seeing here according to the data?
You see a negative 113, and that just means that in this case, the negative is a right turn.
And is that consistent based on your education, training, experience with the the photographs we looked at, which show the manner in which the Challenger was moving to the right prior to the impact?
That's consistent with the road evidence, that's consistent with video evidence, and that also is consistent with the dynamics of that crash.
Your report states Collins, who is the driver of the Challenger, applied a steering input of negative 14 degrees to the right and began to track the left turning Hyundai. Do you see what I'm referring to?
On what page was that?
It's 28 of your report. It's Bates number 35-232. It's the fourth line up from the first paragraph. Bottom of the first paragraph, I should say.
Bottom of the first paragraph, it's a dude, right?
Yeah, it's the third to last sentence, it looks like, of the first paragraph.
Okay. What was your question? I'm sorry.
Do you see the sentence beginning with Collins applied?
I do.
Okay. So I'll read it again. It says Collins applied a steering input of negative 14 degrees to the right and began to track the left turning Hyundai. What do you mean by that?
So the Hyundai's turning left at that intersection. And by that right input, steering input, when I say track, he's actually target fixation is what we call it. He's looking at that vehicle and driving towards the vehicle. So as it's turning left, he's turning his car right into the vehicle.
As the Hyundai was turning left, the Challenger was turning to the right.
Was tracking him, if you will.
Okay. And I believe you said you reviewed the ACM data for the Hyundai as well. Is that correct?
That is correct.
And I think we can get through this one a bit quicker. Were you able to get 5 seconds of pre-crash data for the Hyundai as well? And I'm looking at page 29 of your report, or Bates number 35 dash
Yes, I was.
233.
We did.
5 seconds.
Yes,
Is that pretty standard?
that is, but yes, it changes, but some vehicles are longer and some have become shorter, but yeah, it's pretty standard.
Okay, or the intervals of time as far as when data is provided within that 5 seconds, that
Right.
may vary as well?
And the mandates by the federal codes regarding that.
So just looking at this portion of your report, it looks like 5 seconds pre-impact, the Hyundai speed is 3.7 miles per hour. Is that right?
That is correct.
And then that speed increased to 6.2 miles per hour at 2.5 seconds pre-impact. Is that
That is
right?
correct.
But at 0.0 seconds pre-impact, and I think, would that be milliseconds before for the same reason as you described earlier, or is that actually at the very moment of impact?
So the module is saying, hey, crash is going to happen, about to happen.
So milliseconds
Deploy
before.
airbags. Yes, prior to the crash.
Milliseconds before.
Correct.
Okay. So at milliseconds pre-impact, the Hyundai is now moving up to 19.26 miles per hour. Is that right?
Yes.
Is the Hyundai's ACM data consistent with a scenario where the driver of the vehicle anticipated that the collision was going to occur and attempted to accelerate out of the path of the oncoming vehicle?
It is, so left turning vehicles particularly average between a 10 and 12 mile an hour on average. This increase in speed where you see 19 is exactly how you explained. I believe that he anticipated a crash was going to occur and he's trying to accelerate his vehicle out of the point of impact where he believes these cars, this approaching vehicle will collide with his.
All right, and when you say you believe that the driver of the Hyundai would have anticipated that the crash was about to occur, are we talking just within the interval of that last second, or what time frame are you referring to?
I'm sorry, could you rephrase that? What do you?
Yeah, would it have just been that last second before the crash occurred where the driver of the Hyundai would have anticipated the collision occurring?
So I can't really speak to, get in his head and what he was thinking. But the data indicates that because his left turn was almost completed per video. And so to accelerate as that the opposing vehicle's approaching is why I say I believe that he was trying to move out of the point that he believed these vehicles were going to collide, but I don't know if that answers your question.
No, I appreciate it, Detective. And you mentioned a video, and there's actually a portion of your report, and I think it's a couple pages earlier, at page 26, or Bates number 35230, that's labeled as follow-up investigation. Do you see that?
On page 26. I do.
26 of the 3 pages back, yeah. No problem. And this says follow-up investigation. In what manner was this portion of your investigation a follow-up? Why is it labeled as such?
So, as I explained earlier, we're briefed, we're provided with preliminary detail. I then assume, and my team, along with me, assumes the primary investigative responsibilities. In this particular crash, follow-up will be interviews, if we located video, search warrants, imaging those modules that we spoke about. That's following up with other things.
So this is anything you do essentially after you leave the scene?
No, a lot of that's also done, whether I gotta go speak to, make contact with somebody who may have video, just following up on leads that we received during the preliminary phase of the investigative briefing.
Okay, I appreciate you explaining that. You mentioned earlier that in order to retrieve the ACM data from the vehicles, you had to obtain a warrant. Is that correct?
Yes.
And as part of that warrant was a search conducted of the interior of the Challenger.
Yes.
And did that search yield anything of a significance to you from a standpoint of your investigation?
There were items obtained. Is that what you're asking?
Yeah, I'm looking at the page 7 of your report, or Bates number 211. That's what I'm referring to. If there's anything elsewhere, you're obviously free to refer to it.
Okay, I'm sorry now. Your question, please?
Yeah, you indicated that a search of the interior of the Challenger was performed in addition to retrieving the actual ACM data. Is that right?
Yes.
And did that search yield anything of significance to you from a standpoint of your investigation?
It did.
And what did it yield?
There was a jar, if I remember, containing green leafy substance. I don't recall, miscellaneous paperwork. I believe a basketball might have been in the vehicle, things of that nature.
The jar of the green leafy substance you mentioned, where within the vehicle was that located?
I believe the front passenger seat floorboard, if I remember correctly, but it should be listed here in the report.
Did you interview or attempt to interview any eyewitnesses to this crash, either at the scene or at any point thereafter?
I did.
Right. And we don't need to go through all that. How many witnesses were you able to interview?
I believe on scene, during the on-scene investigation, I believe it was one.
Was that a woman named Robin Lee?
Yes,
Okay. And you obtained a statement from her, is that
I
correct?
did.
And you also mentioned that as part of your follow-up investigation, you're going to be looking for any useful video of this collision or any other. Were you able to obtain any video in this case?
I did.
And from where was this video recorded?
It was recorded. It was a camera affixed to a private residence, a home that was just south of the area of initial contact.
How did you go about getting your hands on that video? I mean, are you guys going door to door? How does that work?
So during the on-scene investigation, obviously in today's times, videos everybody has. Visual. You look at the homes, there's cameras there, businesses in the area. And on this particular location, I observed the video camera. You still don't know if that video camera is may have captured anything or if their surveillance system is working, I made contact with uh, the resident occupant, and she advised me, it was a female, and she advised me she had video.
Were oh, strike that. So you get the video from the homeowner and then I assume you reviewed it.
Yes,
And were the depictions on this, in this video footage consistent with the findings you had already made or your team had already made based on your analysis of the roadway evidence and the rest of your investigation?
yes.
Are you familiar with the term time and distance speed analysis?
Yes.
What is a time and distance speed analysis?
So it's, we're able to, if we identify certain points, and using that video is extremely helpful in this case, we can determine how fast or how much time it took for that vehicle in this particular case to travel past or through those that unknown distance which you measure, and then it doesn't become unknown. You know what how much distance that is. So the time it takes that vehicle to travel that known distance now could you could develop speed.
And in this particular instance, it sounds like you said that the video that you obtained from the homeowner's surveillance camera allowed you to conduct that type of analysis.
Yes.
And what type of information or insight did that time distance analysis lend to your investigation?
The analysis was consistent with the data that we imaged from that airbag control module. Are you asking the number, the speed?
I mean, not necessarily. I'm just wondering what the results of your analysis were or in what manner they were useful to your investigation.
It was consistent. It corroborated the data that we had that was contained within that module.
And I believe there was a median separating the northbound and southbound traffic on Fort Apache in the area of roadway preceding the crash site that you used as your distance marker, if you will, for
Yes.
this analysis.
Yes.
And I don't know if I asked you this before, what was the speed limit for that section of Fort Apache where this crash occurred?
I believe it was 35 miles an hour.
And did the fatal detail team generate any type of computer aided diagram in order to assist with its investigation?
Yes.
Can you tell us about that?
So after briefing, we walked the scene. We identify roadway evidence. We identify the vehicles involved. A device in this particular case, we no longer use this equipment, but it has a GPS tracking on a pole. That's those devices you sometimes see when you drive around, those surveyors that they have. And so it basically it takes data points along the roadway, and through a computer aided diagram, you can build the road, the streets, the vehicle locations, and the evidence that you identified.
Okay. And what type of device is it that you actually use to help with that process?
This, I believe we use, it's called a Sokia, and that's a GPS device that's on this fiberglass stick or pole. SOKKIA.
Is the result of that referred to also as a CAD, a computer aided diagram?
You take the data that you obtain using that device, that receiving device, and with that, you enter it in a software program. And then at that point, it's a computer aided diagram that you convert that data, those data points into a working diagram.
And were the results of, or the findings made from that diagram consistent with the other findings you made through all the other aspects of your investigation we've discussed?
Well, the diagram just gives you a picture of the evidence in the roadway and stuff like that. So what you're asking if the diagram was consistent with the accident scene?
Yeah, consistent with any findings you made through the other aspects of your investigation.
Well, the diagram doesn't trying to explain it properly, the diagram doesn't really assist you in it just highlights the roadway and what you found.
Okay, and I guess what was it used for here?
Here it was to capture the scene as is, because as you know, when we have a police activity, the road is closed. So prior to us relinquishing that road or opening that road back up for vehicle traffic, we have to collect our evidence prior to do so. And this is just another tool that that we can capture a sterile environment as is with the evidence identified and the vehicles at their rest location prior to tow trucks coming and removing the vehicles and us picking up the cones and then relinquishing the road back to open traffic.
Do you have any recollection as to how long you spent on the scene on that particular day or evening, I should say?
I don't. I did interviews. Couple of hours, and then the primary investigator. In this case, and all other cases, you leave the scene over to the detectives who are assisting you with the investigation, and there's responsibilities you have to do back at the police station.
Did you assess whether there were any weather conditions factoring into this crash?
No,
No, you did not, or
no weather conditions.
there were no weather conditions factoring into the crash?
No,
Were there any lighting or visibility conditions factoring into this crash?
no.
And when you're investigating motor vehicle collisions in your capacity as a fatal detail detective, as you did in this case, I believe you said you draw certain conclusions and you make recommendations if needed to prosecutors. Is that correct?
That is correct.
All right. Now, I want to ask you about the conclusions that you drew, but as a caveat, I don't want you to reference any specific codes of NRS or any statutes. All right. So if you could just tell us about the conclusions that you reached in this case without referencing statutes, that'd be great. And I'm looking at page 29 of your report. If there's other information elsewhere in your report responsive, then you can certainly refer to that as well.
So without reciting statutes, we had a DUI resulting in death. We had a reckless driving resulting in death.
Now, if you want to go ahead and look at the conclusions there and provide anything else that you found in that respect, take your time.
It was those two charges I just explained.
And what was the basis of the reckless driving?
Reckless driving, we have a vehicle traveling approximately almost 3 times the posted speed limit of 35. In this case, I think it was 2.5 times the posted speed limit approaching the intersection. That is what the reckless driving, and because we have a confirmed fatality, it's reckless driving resulting in death. The DUI, we had a toxicology analysis come back to support the DUI, also resulting in death for the same reason of a confirmed fatality.
All right. And the driver of the Hyundai was making a left turn here when this crash occurred. Is that correct?
Yes.
All right. And did you offer any conclusions as to his driving actions as it relates to this accident?
Objection, Your Honor.
What's the basis for the objection?
That's going to elicit the testimony we discussed before the witness was called.
Okay, can I have counsel approach? Okay, at this time, ladies and gentlemen, we're gonna give you your afternoon break. We'll give you at least 15 minutes, but if you are running to get a cup of coffee and you take a little bit more, it's no problem. This will probably be your only break today, or we're hoping it's gonna be your only break today. I gotta read you the instruction, then I will release you. So you're instructed not to talk with each other or with anyone else about any subject or issue connected with the trial. You're not to read, watch, or listen to any report of or commentary on the trial of any person connected with the case or by any medium of information, including without limitation, newspapers, television, internet, or radio. You're not to conduct any research on your own relating to this case, such as consulting dictionaries, using the internet, or using any reference materials. You're not to conduct any investigation, test any theory of the case, recreate an aspect of the case, or in any other way investigate or learn about the case on your own. You're not to talk with others, text others, tweet others, Google issues, or conduct any other kind of book or computer research with regard to any issue, party, witness, or attorney involved in this case. You're not to form or express any opinion on any subject connected with the trial until the case is finally submitted to you. It is 2:31 right now. I'm just gonna ask that you come back at 2:45. And like I said, if you need an extra minute because you're running to Starbucks or something, feel free to take it. We wait for you. Thanks. Everybody go ahead and have a seat. The door's closed. Okay, we are outside the presence.
We released the witness.
Might be important for him to hear some of this, so he understands what the limitations are on his testimony. That might kind of solve some of these problems. But is anybody requesting we do?
No, I agree with you. I think you should hear what we're
Okay.
trying to exclude.
We have not completed your testimony yet, if that's not clear, but we do have some concerns from some of the counsel that have been raised. So why don't we recap what we were doing at the bench so that we can make a nice clear record?
So counsel asked a question that was designed to directly elicit the statement that we had discussed off the record before the jury came in with respect to the detective's conclusion of Mr. Collins's legal forfeit of a right of way. And we discussed how that would be a legal conclusion and be impermissible. Mr. Chu indicated that he was attempting to skirt around that the best he could to get what he needed from this witness. And from my perspective, and I'm sure Mr. Chu has his own opinion on this, but from my perspective, everything that he stated he needed from this witness, he's already obtained through that testimony.
Okay, response.
Judge, the question that was objected to was actually not asking about whether Mr. Collins forfeited his right of way. It was asking about whether the decedent's left turn was appropriate under the circumstances. And there was no intention to elicit a legal conclusion. And I'll just reiterate that this is distinguishable from Frias in our view. This is not a beat officer showing up and taking a 3-page report. This is the result of a 35-page comprehensive investigation. We've heard of all this.
Okay, why don't we do this right now, since we're outside of the presence? As an offer of proof, why don't you ask the question you want to ask? We'll let him put his answer on the record. We are outside of the presence. And I'll see what he has to say, because part of the issue we have with this witness, and this is not any, I'm not taking any fault with you, sir, is we don't, when I've been asking, what do you think his answer is going to be? We don't know what his answer to some of the stuff's going to be. So why don't we see what his answer is going to be? If I don't allow it, you've got your offer of proof on the record for whatever you want to do with it later. And if I allow it, then we don't have an issue, but let's hear what his answer is going to be. Let's hear your question. And let's go from there.
Okay. I'll do so. And I guess, Judge, the only other thing I might ask is the portion of video that we played earlier outside the presence that was not objected to when we played it earlier. If we could play that for the officer and ask him whether based on his investigation, he agrees with that statement by his fellow officer.
But it's not him, right? Or do we not know if it's him?
It's not him, but we're not. First of all, there's no dispute as to
If you want to do your offer of proof, you can, but I'm probably not going to allow you to do that in front of the jury. But if you want to put that on the record now as an offer of proof, that's fine.
Yeah, as my offer of proof, I wouldn't want to do that, Judge. All right. Detective.
No, do you understand what I'm saying? I'm excluding that. So if you want it on the record to prove what I excluded, I don't have a problem with you putting it on the record to prove what I'm excluding right
I
now.
understand. What I was proposing was instead of doing an offer of proof, in front of the jury, but I'll go with the offer of proof route.
Okay.
Detective. Do you have an opinion as to whether Mr. Collins driving the Challenger had the right of way as he entered the intersection where the collision occurred?
I do have an opinion.
And what is your opinion?
That Mr. Collins carrying the speed he was carrying, traveling, as you say, 35-mile-an-hour posted speed limit, forfeiture right away.
That Mr. Collins forfeited his right of way as a result of the speed with which he was carrying?
Right, correct. He's almost 3 times that speed limit. And he's approaching an intersection. Yes.
Okay, let me ask you a question. Sorry, because I want to make sure. Do you have any law that you base that on?
As far as,
In the microphone.
Oh,
It's okay.
sorry.
I know you're talking to me.
I'm sorry.
You don't have to look at me though. Do you have any law that you base that on?
no,
No, okay, thank you. That's why I'm excluding that, just to be clear.
that's just my opinion.
Okay, Detective, did Mr. Echevarria, who's driving the Hyundai, to your knowledge, was he cited as being at fault for this crash, either by yourself or by the initial traffic officer responding to the scene?
I'm sorry, Mr. Echeverria.
Was the driver of the Hyundai
Huh?
cited as at fault for causing this crash?
No,
And was that a decision you made or a decision made by the traffic officer at the scene prior to you?
so that was what he briefed us, his deliberative investigation revealed. And obviously, we assumed the primary investigative responsibility. Our investigation revealed that. And then it's a vetting process as well. When my investigation is complete,
Hold on a second. Did you say betting or vetting?
vetting.
Okay, with a V.
Yes, ma'am.
Thank you.
And so when my investigation is complete, it goes up my chain of command, who also vets, because they were out there as well, and they have to approve these reports. And so there is a vetting process where collectively, the decision out of my investigation and a decision from my detail through my supervision is also vetted, and we all came to the same conclusion.
And your investigation led you to believe or to agree with the determination that the driver of the Hyundai was not at fault for this collision, is that correct?
That is correct.
And what specifically about your investigation led to that opinion?
Well, you have a young man who's traveling in the vehicle in a surface street, residential homes, multiple intersections. He's traveling almost triple, digit speeds. He's at almost 3 times the posted speed limit. He's also operating that vehicle under the influence of a controlled substance. We have a left turner who is approaching that intersection to make a left turn into his community. Now, why speed is such a factor? With the exclusion of the obvious, the damage that is caused. If I'm making a left turn and I miss the Echevarria at that intersection, that vehicle is hundreds of feet down that road. It's safe for me to do so. I can't judge that closing distance because I don't know that that's coming to me at that speed. So I begin my left turn and I, just assuming on the average response, and that vehicle now is not all the way down there because the closing speed is so fast. And that's why I believe that velocity increase at the end of his left turn, where he's trying to get out of the approaching vehicle's way, is because that vehicle is now on top of him because it's traveling so fast. Now, had Mr. Collins had 2 options, right? With the exception of the ones we just spoke about. Had he been traveling the posted speed limit, or even above it, that crash doesn't happen. Had he not target fixated or tracked him, if he maintained it straight, did not turn that wheel, Echevarria would have made his left turn and cleared the area of initial contact. And Mr. Collins would also have avoided that collision. So those factors and the totality of those circumstances, he's at fault for the crash.
What you described towards the beginning of that response about from the driver of the Hyundai's perspective, Mr. Echevarria, the difficulty with perceiving the closing speed of the oncoming vehicle due to the speed of that vehicle. Is that a topic that you were trained on and was part of all the education and the courses that you took in order to become a fatal detail detective that you discussed with us at the beginning of your testimony?
Yes, it's just not the classes, it's the thousands of investigations, crash investigations. I mean, it's not really complex. It happens on your way home from this hearing. You'll see a left turn. I mean, if I see a vehicle where there's enough distance for me to safely make my left turn, but because I can't determine a closing speed, assuming, right, this is a 35-mile-an-hour traveled road, and I start my turn and I commit, and then all of a sudden that vehicle's on top of me because it's traveling so fast and I had no idea. So it is safe for him to make that left turn, because the minute he initiated the left turn, that Challenger was hundreds of feet down the road.
Based on the entirety of your investigation, did you conclude, or your view, were the driving actions of Mr. Echevarria and the Hyundai reasonable?
Absolutely. If it was me and I make this left turn and I have a 2.5-ton vehicle traveling at that speed approaching me, I am speeding up as well to get out of there, because I'm going to get hit. And these things are happening fast. He has seconds to make a decision, just as the opposing driver does as well. I'm a detective, almost 20 years. I am speeding up to make that left turn to get out of the danger zone. So I think his actions were is something that is something I would do, if that makes sense.
It does. Course indulgence.
Sure.
Your Honor, do you want us to keep going? I think the last thing you just went over about the distance and where he would have been when he decides to make the turn, I think all of that section was fair game based on his investigation, his accident reconstruction, his report, everything else. So I guess the question here at this point is, will Mr. Chu be ready to ask that?
And I'll recall, I'll just emphasize that the disclosure, to the extent we're still abiding by that, I believe specifically references
The disclosure does reference.
measurements
close to that.
compiled amongst the other items that are fair game for this
But
detective
which,
testimony.
the measurements compiled, those are all coming in. Those all already came in front of the jury, didn't they, when he was talking about the cones? Can you put up the picture again with
So,
the point of impact and the cones?
It's 7207.
I thought that was the exact thing he went over. So I'm not limiting, I want to be clear, I'm not limiting any of his measurements compiled, any of his photographs taken, any of that. But the objection that I have, well, I think actually there were two objections made today that were new on this. One, him offering legal conclusions, and two, the traffic accident report coming in, not, the citations coming in. Were the citations or just a traffic accident report? Are you objecting to the citations?
There were no citations as a result from this accident. He was arrested and charged with reckless driving.
Okay,
That I'm
so,
aware of. I mean, unless I've missed something, but I don't remember seeing traffic citations as a.
and this says the issuance of traffic citations to defendant Zaon Collins. It doesn't say the lack of issuance of traffic citations to plaintiff.
May I clarify here?
Sure, go ahead.
What he just went over, that last section about how far away he would have been when he decides to make the turn, that wouldn't have been anticipated, and that he would have not seen it until the last second. That was all based off of his measurements, his reconstruction, everything else he did. So it's not just his measurements. We're now getting into conclusions from the measurements without talking about specific laws, without talking about the right of way. So I think that's all fair game.
Okay, so his conclusions for the measurements are what? Because, look, I can see the measurement, and I think it's consistent with what your expert said, that the point of impact is in like the bike lane, correct?
Right, but it's not just the point of impact. It's the next step from the point of impact that when Mr. Echevarria makes the turn, he wouldn't have, Mr. Collins would have been so far away, he wouldn't have realized that Mr. Collins was a threat to him. That's the conclusion.
Yeah, but your expert said that. Your expert said it was a reasonable turn. And your expert was an accident reconstructionist, and I'm not trying to take it away.
No, that's fine, man.
Any of
It's your
your
court,
professional
sure.
background, sir,
No.
okay?
Oh.
But you're on the stand in a different capacity than an actual disclosed expert in this case. And look, I made some rulings because of what was disclosed. You had a disclosure that revealed what this person was gonna say on the stand, this detective was gonna say. So I did make some rulings based on that. And I allowed a certain amount of his disclosure in for that reason. Actually, I allowed what you've disclosed here in, but the problem is, we're now getting different objections from opposing counsel. One of them being, he shouldn't be able to offer legal conclusions, which I think is a fair objection. And I sustained it. This witness shouldn't be giving legal conclusions. That's for the jury to determine. Okay. And the other one I thought was a Frias objection, which actually I allowed us to a lot of stuff in because I didn't see Frias as applicable here because we're dealing with a 34-page report versus Frias and correct me if I'm wrong, but Frias was an officer, I think, doing cursory investigation of the scene and taking statements from people who were at the scene. So he was basing his conclusions on third parties, or maybe he was a third party. I believe it, yeah, third parties and cursory investigation of the scene. I think he's made the point that he did much more than a cursory investigation of the scene, which is why I'm letting him put a lot of this stuff in. And he has made a lot of statements already, but I'm a little bit worried that we're going too far here with the witness, with what's been disclosed and what's in his report.
I understand, and just addressing those two things, the legal
Do it.
conclusion, it's not a legal conclusion when he's saying that by the time Mr. Echevarria makes the turn, Mr. Collins is so far away that he would not have been a risk to him in the intersection. That's a calculation based off of the distance, the measurements, the speeds, all of that. So he's coming to the conclusion that because he's
Okay, so
far
let him
away-
give his measurements, that when Mr. Echevarria started his turn by my measurements and calculations, Mr. Collins was X amount of feet away. You can give that. If
I
that's
understand
what you want to give, I think that is in here somewhere or something to that effect.
But that's an opinion. That's the next step from the measurements. And it sounds like you're not allowing his conclusions based off the measurements, that how far away Mr. Echevarria would have been, Mr. Collins would have been from the intersection when Mr. Echevarria makes the turn, that Mr. Collins would not have been a threat to the intersection because he was so far away. Because that's what he just went on to explain in intricate detail based off his measurements. So I don't think that's a legal conclusion. That's a fair opinion. It was disclosed. It's discussed in his report. I think it's fair game.
Which sentence of the report are you talking about? I'm looking at the conclusions on page 29. Let me know if I need to look at a different page.
Well, it's imputed from the fact that he would have cleared the intersection had Mr. Collins not been going that speed. So with that said, I think he can also come to the conclusion that, and it's within the scope of the charges he recommended, that Mr. Collins' actions were the cause of the collision. Is to
He
say,
didn't say that already. Something very similar to that. He already said.
I didn't hear him say that Mr. Collins' actions were the cause of the collision. I did not hear
Everybody's
it.
getting the dailies, right? So you'll see it when he said, what was the phrase? You were asked about the accident, sir, and did he not say it was? We could rewind at this point. I could have her look, but I'm also a little concerned with how far ahead we've gotten, that it's gonna be hard to find, but I did hear him say that this was reckless operation of a vehicle or something to that effect, and a DUI.
That doesn't mean, that's different than saying Mr. Collins' actions caused the collision. Those are,
Okay, but this is an ultimate question for the jury in this case. Like, this is actually a question for the jury in this case. I understand why you want this witness to say it, and it might be his opinion that that's what it is, but the problem is, I don't have what you want in here about your client. I don't see it in here directly in his conclusions here. And the additional comments that you want that aren't about your client, that essentially you want this witness, as I'm hearing you to say, that this accident was Mr. Collins's fault. Again, to the extent he can say that, he's already said what's in his report, with the exception of the legal conclusion, which was, I'll read it too, right out of his report. Collins forfeited his right of way by traveling more than 2.5 times the posted speed limit of 35 miles per hour as he approached the intersection. I'm not letting him say that because I do think that's a legal conclusion that would be inappropriate for this witness to make.
that he was going over 2.5 times the speed limit when he approached the
You've
intersection.
already got that in. He already said multiple times he was going over 2.5 times. And I think that was his findings, that those were his measurements, that was what he got off of. Did you call something different than the black box of the car? Did you use a different?
Control module.
Oh, the control module. That was what he got out of the control module when he checked the numbers. So you got all of that
Can I
in.
show you what Mr. Chu has not gotten to that is in the report?
Sure.
Okay, page 29, it's right above the conclusions. It's literally the last sentence above the conclusions where he said, Eric Echevarria would have successfully cleared the AIC and avoid the crash had Zaon Collins not tracked the Hyundai by applying a steering input to the right, as well as grossly traveling over the posted speed limit at 35 miles an hour. Those conclusions are based on his calculations and everything he has already testified to as the foundation. I think those are all fair game. They're not legal conclusions. They're in the expert report. They were in the disclosure that we disclosed as far as the scope of the description of testimony. I think that's all fair game. And Mr. Chu has not gotten there yet, Your Honor.
Okay. What is your opinion on that coming in?
On that particular issue, I believe that this witness has talked about whether or not Eric Echevarria would have successfully cleared that AIC had Mr. Collins not been going the speed he was going. At this point, if they're going to leave it at that and be done. Sure.
Okay, so it doesn't sound like there's an objection beyond what's already been raised to that last sentence of the paragraph directly above the conclusion. So do you want to try to get that in?
Yeah, that's fine, Judge.
Okay, anything else? And look, you've made the offer of proof as to what he would have said. Do you want to do any additional offer of proof before we bring them back in and you ask questions or a question about that last sentence? Because I would like to not take another break with the jury if we can before the next witness. But if you want to do any other offer of proof, we have the witness on the stand right now, so why don't you do it?
Not at this time, Your Honor, but I just want to, if I can just finalize my record, if I may, Your Honor.
Yeah, go for it.
The last thing is, when Mr. Terry was asked about the right of way, we did object, and the objection was overruled. So the problem here is Mr. Terry was allowed to testify about the right of way.
Yeah.
So I don't, what's confusing me is as to why this witness is not allowed to testify to the right of way. If it was a legal conclusion when they asked Mr. Terry it should have been sustained at that time. So if it wasn't a legal conclusion at that time, then this witness should be able to testify to it as well, if that makes sense, Your Honor.
Okay, do you want to respond to it? Do you have any, I'm sorry, I don't remember exactly what was asked of Mr. Terry, but you're saying at some point defense asked Mr. Terry or you asked Mr. Terry?
They asked Mr. Terry
Okay,
if Mr. Collins had the right of way.
okay,
We objected and the testimony was allowed. So if that was allowed from Mr. Terry at that time, it should be allowed from this witness as well, who had the right of way.
So if the question is posed to this witness as to who had the right of way, right? The law states that the driver going straight has the right of way, but it's this detective's opinion that he forfeits that right of way, and that is not based. So, and that is not an appropriate opinion. So I suppose if he would like to. And here's the problem, right? Now, and now the detective has heard kind of what we're trying to do, and I'm not saying that the detective would try to do it, but he.
here's the
could
thing,
see-
he's not like, no offense, like I said, you're not being Nobody's paying him to be here,
Right, yeah.
as I know, okay.
And he probably really hates civil attorneys more now.
I did.
And Your Honor, just briefly, the law does not state that Mr. Echevarria, the law does not state that Mr. Collins had the right of way. Defense counsel keeps saying that, but the law is more intricate than that. And that's why it was an issue when they asked Mr. Terry who has the right of way. So if Mr. Terry was permitted to testify to it, this witness should also be permitted to testify to it. If it wasn't objectionable at that time, or if the objection was overruled at that time, this witness should
Well,
also.
I don't remember the reason for the objection when that was made. I honestly, I am not as clear as I would like to be on the history of all this. If you guys want to pull does somebody have the daily for that? And I can see the actual question, the objection, the reason for the objection, the reason for my overruling it.
Regardless, the jury, as we just discussed this morning, the jury's going to get an instruction on NRS 484B.253, which is vehicle turning left. So it's irrelevant to ask this witness anyway.
If it was irrelevant, then I'm assuming it would have been ruled when we objected when Mr. Terry was asked the question. That's the issue now.
Okay, well, pull up the question to Mr. Terry. Let's see
Judge,
what that question actually was.
I am.
And let's see what the reason for the objection was, because there might have been a different reason for the objection than what's being given now, which also does factor in. So it's a little hard to do what we're doing right now, where we say, well, this happened earlier.
While he's looking it up, Your Honors, the position is that they desperately tried to get this learned detective to testify to the words that were in that report, and it didn't come out. And so it didn't work out.
Okay, I'm not seeing that they're wanting testimony from him from the words exactly in this report. I was under the impression they were wanting testimony from him that their client didn't do anything culpable in here, or, I mean, that's what I'm seeing.
They were going down the report in the area, and the detective said he forfeited his rights to the right of way. So if
Okay, I didn't see them trying to say that, but I understand what you're saying, but we already went over that kind of ad nauseum at this point.
Oh, I agree, Your Honor. They're going to get an instruction on what the law is on the right of way, and asking this witness who's basically brought in to make that opinion, because everything else is what the experts report is inappropriate. And I think you've made that excellent record on that, and it's been preserved. Thank you.
So the objection, if I may, was at page 189 of this transcript, and it states, and you agree, though, that when a person is making a left turn, excuse me, let me start later. And you would agree generally that people turning left need to yield to oncoming traffic. Mr. Ladah lodged an objection. Objection, Your Honor, this is the ultimate decision in the case that she objected to.
Okay.
I responded, I asked a general question about the rules of the road with which Ms. Terry has already testified to. And the court overruled the objection.
Do you want to ask a general question about the rules of the road to the detective?
As far as it would be whether the right of way can be given up, something of that sort. I think that's just as general as what defense counsel asked.
Okay, what will be your question?
Question would be something like, can a person going straight give up the right of way if they're going too fast? It's within the scope of what they asked Mr. Terry. I think it's fair game.
We never asked Mr. Terry anywhere near that, neither did counsel.
No, you asked generally if a person going straight has the right of way, right?
Correct.
Okay, so would your question be generally, can a person making a left turn have the right of way? And
Yes, Your
under
Honor.
what circumstances?
Oh,
Is that what you want to ask him?
yes, Your Honor.
Okay, what would be your answer to that question? Generally, if a person making a left turn has the right, or, okay, go ahead, why don't you ask him? Let's see what your answer
Generally,
is.
can a person turning left, no. Can a person turning left, get the right of way if the if another car is going too fast?
Ask in a different way.
Yeah,
because-
I'm sorry, let me think about that. Well, why don't I do it this way? Generally, can a car going straight give up the right of way? Generally,
Generally, yes. If this fact is involved, right? So if speed limit, even above the speed limit, he doesn't, the straight vehicle, traveling vehicle, 15 miles an hour over doesn't relinquish his right of way, even though he's traveling above the posted speed limit, if that makes sense. But in this case, with the speeds that we have, that vehicle that's traveling straight, or in this case, it was northbound, gives up his right, in my opinion, gives up his right of way. And as I could explain why I say that, but I don't want to go outside your question.
No, right now is the time for you to say whatever
Okay,
you want to
the
say on
reason-
the record so that we can figure out what we can and can't put in front of the jury. Because part of the issue that I'm having in this case with counsel objecting is I don't know what your answers are gonna be to some of these things, and they don't know what your answers are gonna
Understood.
be. And like I said, I've already made a ruling that it wouldn't be appropriate for you to give legal conclusions. And there's other limitations, but that I do think it's appropriate for you to testify as you've been disclosed with some exceptions. So if you want to go ahead and elaborate and let us know what else you would say to that answer.
Okay,
to
so-
that question.
Sure, Judge. So my elaboration is that vehicle that's traveling straight, that's his road or her road, right? If I am the left turner and I am going to cross that path of travel, that is not my road yet. And I'm trying to simplify it. The way it becomes my road is that vehicle's hundreds of feet down the road. I can make and conduct my left turn safely. But what I don't know is the fact that that vehicle is traveling at the speeds that we have in this case. So the closing distance changes everything. But when I'm making my left turn, the perception is that it's safe for me to cross his road. And because of his speed, he forfeits his right of way, if that makes sense.
Okay, and your objection is the same.
Calls for a legal conclusion. It's not in the Nevada revised statutes, and it lacks foundation. And it calls for an expert opinion improperly disclosed.
Okay, response.
it's not a legal conclusion. If it was, it would have been, shouldn't have been allowed for Mr. Terry, is our position. It was disclosed because it's within the course of his measurements and his conclusions based on all his calculations. I think it's fair game, Your Honor.
It's also ultimate opinion in the case, which goes to the jury to decide, as we've reiterated several times.
Which is my same objection with reference to Mr. Terry when they asked the question.
Go ahead.
Bottom line is, the detective was very honest. He says in his opinion, that's not.
You're talking too quietly to even be on the record, sir. You know that, right? You gotta stay near a mic and you
I'd like
gotta
you to
raise
hear
your
me
voice.
there.
I can hear you just fine,
All right.
but I bet you're not on the record.
Is that they want to get the detective, in his opinion, which he's plainly stated, in my opinion, he forfeited the right of way because he's going too fast. That's not the law. And that's why he wanted to exclude it. Thank you.
The law requires some discretion, some opinion from the evaluating officer, because otherwise it would just be any car going straight will always have the right of way, no matter what. They could be going 300 miles an hour. It requires the officer to look at whether the straight car is within the intersection or so close thereto as to constitute an immediate hazard, which requires the discretion and the experience of the issuing officer. And I will just add that this same question was also posed to Zaon Collins without objection when the video was played during Mr. Ladah's examination of him. And I can,
What question was posed to Zaon Collins?
yeah, I'll tell you right now. It is, and this is on page 96, beginning on line 25 of last Friday's transcript. Question, okay, do you remember when the officer told you that you gave up your right of way because you were driving so fast? Answer, no. Question, can we show that, Joe, please? Video recording played at 12:02 PM. So,
But then you have it in. You have an officer telling you that, but that's not this officer.
right, I guess we're bringing this up to demonstrate that this has come up. In this instance, it came up with a question and a video without any objection to either. I'm not sure why it's such an issue here if it wasn't there.
Okay, so I think the equivalent question to what was asked of Ms. Terry is something to the effect of, are there circumstances under which someone left turning has the right of way? Something to that effect. If you were asked that question, are there circumstances under which someone left turning has the right of way? What is your response, sir?
I'm sorry, man.
If you're asked the question, are there circumstances under which someone left turning has the right of way? Let me ask it again.
In the instance,
Sorry, you gotta stay near the
I
mic too.
apologize. In the instance, that we see in this crash, we have a,
Not in relation to this crash, but are there circumstances under which someone left turning has the right of way?
when, the intersection that they're crossing, making a left turn, it's safe to do so because of the distance of the approaching vehicles.
Okay, you can ask that question.
Okay.
That's the equivalent to the one asked Mr. Terry. You want to object to it, you can put your objection on the record now, or you can do so at the end of the day. I imagine that you have an objection. Sure, go ahead.
And so I would generally object to that question and answer. I think it goes beyond what Mr. Terry testified to and what was asked. of Terry, and the whole reason I asked Mr. Terry that question was because he was allowed on direct examination to answer questions about the rules of the road that were contained within his report. That was a fair game question based upon plaintiff opening the door with Mr. Terry. That has not happened here. They can't open their own door with the detective. And that goes to the ultimate issue in the case and calls for a legal conclusion that isn't even consistent with Nevada.
Okay. Okay, and that I will permit because there's stuff in his report that supports what he's gonna say, but I'd like you to keep it general, not legal conclusion based on this case. Understood?
Thank you.
So the answer you just gave is fine, if that's what you get. Does that make sense to you?
But isn't it?
Are there circumstances
Is it
under
vague?
which someone left turning has the right of way?
Say it that way.
No, that's the question you're gonna be asked, or
Okay.
something to that effect.
And we're assuming your answer is similar to what you just said.
But your answer should be given generally, not in this case I found, but are there circumstances under which someone left turning has the right of way? Okay. Okay, we'll make more of a record later, because I'm sure there will be one. Anything else before we let him in? Oh, you gotta use the bathroom? Okay, we just gotta take a short break. You just give us 5 minutes. Do you want to use the restroom? Yeah, you have 5 minutes if you want to go ahead. To the hallway.